Thank you, Paul, and thank you, Willis and Joseph. So far today, our attendees have heard about FFIs and IGAs, responsible officers, and the focus has been on basically the FFIs and how they comply with FATCA. FATCA has, of course, another aspect to it, and that is the aspect that deals with U.S. taxpayers who likewise have to file information returns that have been brought to us by FATCA. And the first, if you could advance the slide to 46, please. This is a schematic that I think helps us understand where we are and what's been happening over the last several years. This we took from the GAO website that has, of course, three columns: the taxpayer column on the left side, the Internal Revenue Service in the middle, and financial institutions on the right side. Prior to FATCA, it's very faint on your screen, but if you go about 2/3 down, you can see a dotted line that's barely visible. But above that dotted line, about 2/3 down, we had the reporting regimen that was in place prior to enactment of FATCA. And of course, for taxpayers, individual taxpayers, as illustrated in this schematic, you have the Schedule B. You had the obligation of taxpayers to include any interest, dividends, or gains and losses on their U.S. income tax return. And then, of course, the taxpayers had the obligation to file the financial bank annual report, the FBAR. In the middle, of course, IRS is the recipient of the information that the taxpayer provides when the tax is self-assessed on the 1040 or the requisite income tax return. And then for purposes of validation, on the right-hand side, if you look at the right-hand column, of course, we know that U.S. banks in the upper right-hand corner had given information themselves to Internal Revenue Service, which enabled IRS to compare the taxpayer submitted information with the financial institution information and verify that, in fact, all has been reported. Of course, prior to FATCA, there was no reporting by the foreign financial institutions, or FFIs, of information to the Internal Revenue Service. FATCA, as you know from both Willis and Joseph's talks, has brought that obligation to FFIs. And also, in the left-hand corner of the schematic, again, we have the IRS Form 8938, which is required for individuals. Why don't we move to slide 47. FATCA, of course, was enacted in 2010. For the Form 8938, we've been through 3 different filing seasons now. It started with 2011 filing, that is the filing of the 2011 returns. So we've been through 3 different filing seasons, and I trust that by now a lot of our attendees are fairly well acquainted with the obligations and what must be reported on Form 8938. So for the moments I have this afternoon, I don't intend to go into any real detail on Form 8938. The form does have multiple parts, but essentially the taxpayers are obligated to report their foreign financial assets on the FBAR, or I'm sorry, on the Form 8938. Why don't we move now to the next slide? And by the way, for my presentation, there's also a subsidiary, or I should say an appendix that is available that gives you more details on the Form 8938 that you can access, but it's not in the main body of my presentation. All right, next. Most of us are familiar and hopefully have become aware that the dreaded label, the Form TDF 90-22.1, which is a mouthful, has actually been shortened, and now it's simply a Form 114. This is the Foreign Bank Account Annual Report, and it requires taxpayers to file this report that obligates them to report the ownership of any foreign bank or similar type investment account that has a value at any point in time during the reporting period of $10,000 or more. This report used to be filed by mailing or manual filing, and it was submitted to a Treasury unit in Dearborn, Michigan. Starting with the the June 2013 filing, electronic copies, or I should say electronic filings only, are now accepted, and that is true both last year as it will be again for this year. And this deadline is fast approaching. The return must be submitted by June 30 for the year following the calendar year that's being reported. Okay, let's turn to the next slide. There would seem to be, and there are indeed some overlaps between what is reported on the Form 8938 and what's reported on the FBAR. The FBAR, of course, has a reporting threshold of $10,000 or more if at any time during the course of the year the account value exceeded that threshold. But the thresholds for filing the Form 8938 vary depending upon the nature of the taxpayer being a single or joint return, or residency, be it inside the U.S. or outside of the U.S. There are different reporting thresholds that apply. The Form 8938 has its origin and its authorities really in the General Tax Administration. But the Form 114 more pertains to law enforcement. We've cited on this slide 49 a website that you can go to where you can get a more detailed comparison between the Form 8938 and the FBAR. And if we go ahead to slide 50, we'll see a partial excerpt that's lifted from that website. If you look down under reporting thresholds under Form 8938, just to give us a common foundation for single individuals, if at the last day of the year the foreign assets exceed $50,000, or if at any time during the course of the year they are at $75,000 or more, then it triggers the obligation on the part of the taxpayer to file the Form 8938. Those threshold amounts are increased for a married filing jointly couple to $100,000 on the last day of the year, or $150,000 at any time during the course of the year if those individuals are U.S. residents. If they're resident outside of the country, a single individual goes up to $200,000 reporting, or $300,000 at any point during the year, and likewise the limits or the thresholds are increased to $400,000 and $600,000 respectively for married filing jointly who reside abroad. Why don't we go to the next slide now, slide 51. As you've heard from Willis and Joe, FATCA's efforts are primarily designed to obtain information from FFIs that helps IRS do the validation. But it's helpful for us because we are in an environment right now where more and more FFIs will be reporting information that will ultimately be received by the IRS. It's important for us to know and to be able to advise clients that if they have not previously reported the results of their holding of foreign financial assets or bank accounts, etc., that there's still a window available. And this has been pretty well chronicled over the last few years. It started with the big news of the UBS case back in 2008. And it still is pertinent today, and I thought it would be helpful to spend a few moments talking about the elements of the offshore voluntary disclosure program that we have today. Historically speaking, the FBAR report was actually enacted by Congress in the early 1970s. It was administered or enforced by the financial crimes units within the Treasury Department. Over a period of about 30 years, there were about a dozen cases recommended for criminal prosecution. It was lightly enforced. And probably in the year 2002, 2003, estimates have been that there was about a 20% compliance ratio across U.S. persons who were required to file the FBAR who actually did. So we had a huge degree of noncompliance. 9/11 hit. In 2003, Congress passed legislation that moved the administration of the FBAR from Treasury directly into the Internal Revenue Service, and we had our very first voluntary disclosure program in 2006, which enabled people, if they came forward with full and complete disclosures of foreign-owned assets and income and filed amended returns, that starting in 2006, there was a program that had a short life that enabled people to become compliant, and with the understanding that there would not be a criminal prosecution related to their past delinquencies or failure to file returns. In 2009, given the developments with UBS that happened in 2008, the IRS came up with a new program that ran for about a six and a half month period that solicited and encouraged people to become compliant in exchange for a non-prosecution type agreement. And that program was hugely successful. It was repeated again in 2011. It expired, and then finally in January 2012, Internal Revenue Service came out with a program that still exists today, and that's available for taxpayers who have not yet complied and filed the required returns. It's still possible for those individuals to submit themselves through the OVDP program to file amended returns for the past and pay the tax. Why don't we move on to the next slide now? Okay, slide 52. If the individuals file amended returns for the 8 prior years, file the Form 114 for each of those years, and if the taxpayer further agrees to pay any additional tax, the interest on the tax, a 20% accuracy penalty, and then on top of all that, the taxpayer would be obligated as a obligation under this program to pay a high watermark penalty on the highest aggregate account value that the taxpayer had during the non-reporting period. In the outline on page 52, it lists 27.5%. So if we applied that, if a person had an account balance of $1 million, then $275,000 would be the high watermark penalty associated with that noncompliance under that program. It's possible, although it's not listed in your outline, it's possible that if the taxpayer, through that 8-year range of period, had only $75,000 or less of account values as their high water mark, the 27.5% penalty rate could be reduced to 12.5%. And further, if the taxpayer basically inherited an account or left it dormant, it's possible for the individual to have instead a 5% penalty that would be applied against the high water mark account values. If the taxpayer is able to maneuver through the program, you have to submit bank statements, a computation of the high water mark penalty, and be prepared to answer a whole sort of questions about how the account was originated and what economic activity gave rise to the creation of the account balance in the foreign country. If in the outline of the third bullet point, it lists that this is only available for legal income cases. If the taxpayer happened to engage in illegal activities to generate the account balance, then under the terms of the program, the person would not be eligible to participate. There cannot be a prior IRS contact, and that's especially relevant today in the environment we're talking about here on May 28th, when we have FFIs about to submit information to taxpayers or concerning taxpayers that if IRS obtains that information before the taxpayer makes a voluntary filing, then the person is not eligible for this program. So you've got to be the first one to the door to drop in on this. Some taxpayers who are in the program and the IRS guidance on the program tells us that if you're not satisfied with the high watermark penalty, you can opt out of the program after you make disclosure. Then essentially you're arguing the appropriate penalty that will apply for the non-compliance on the FBARs. The statutes permit the penalty to be as much as 50% of the account balance for each and every year that it was outstanding. So feasibly, if the worst of the scenarios were to develop, it's possible for the taxpayer to pay 50% of the account balance in year 1 for penalty, 50% in year 2, et cetera. And before you know it, all the account is decimated, and you're looking at paying the balance of the penalty from other U.S.-based assets. Why don't we go on to the next slide? There is also the possibility, and this slide references the streamlined filing compliance procedure for non-resident non-filers. The Internal Revenue Service developed this program and released it in September 2012. And this program essentially says that if a taxpayer is a non-resident, that is non-resident of the United States, had the obligation to file a U.S. return but did not, and did not file the FBARs, then rather than submitting to the full-blown OVDP that was on the slide before with the 8 years and all the bank statements disclosed, et cetera, instead what the person can do is avail themselves of the Streamline program. In order to do this, you have to have a tax understatement no more than $1,500 per year. If the tax understatement in any given year of the range exceeds $1,500, then you're not eligible for the Streamline program. But under the Streamline program, the taxpayer would file amended 1040s for the 3 years immediately preceding, and the FBARs for the 6 years immediately preceding. And then essentially, if the taxpayer pays the tax and the interest associated with the tax, then that should be sufficient to close out and enable the taxpayer to come into compliance for all past periods. This program, the Streamline program, though, a couple more comments. First, if a taxpayer submits under the Streamline program but is not eligible, then they are disqualified from moving it over into the OVDP program. And secondly, there's no guarantee with the Streamline program that there will not be a criminal prosecution. So the taxpayer is going to be taking a bit of a leap of faith, has to be absolutely sure of the tax understatement and the account balances and values, and then could make a determination. Under any program or any time a person files an amended return, I always counsel clients that you must make sure that you're coming not partway clean, but completely clean in disclosing any potential liabilities.
David, if I might just interrupt you here, I have to issue a secret word and a reminder. We're running a little long on time, so I know you have a lot of slides left, so we're going to give you till about 25 after. If you could shoot for that, that's about 7 minutes. And while I have the floor here, secret word number 4 for the attendees is preparer. P-R-E-P-A-R-E-R. Preparer is the 4th of the secret words, and you'll need that for your continuing education credit. Preparer is secret word number 4. And sorry to interrupt you there, David, but we did need to do that and the reminder because we have one more presentation, and we would like to get to some Q&A. So if you could shoot for 25 after, that'd be great, okay?
Thank you, Paul. Last comments on the Streamline program. There must not be any economic activity of any material type inside the U.S., and the taxpayer cannot hold a bank account outside of the country of residency. So there are risks with the program, but it may be available for people to be considered. Why don't we move on to the next slide? Again, this summarizes where we are with regard to the rapidly closing window. I think we should come away from this program today. If we don't already know it, we have a new normal. The environment today is different than it was 5 or 10 years ago. The taxpayers still have a chance, if they have not yet availed themselves of the OVDP, if they have accounts, to do so. But the word is it has to be done, quickly. The last bullet point on this slide references what are your firm's internal reporting or practice standards as it relates to Treasury Circular 230. Let me go to the next slide. Treasury Circular 230 applies both with respect to tax advisors who are giving tax advice on income tax issues, but also could be excise tax returns and additionally information returns of a sort and a type that we have talked about so far today. And I thought it would be helpful to list the standards here. These standards apply to CPAs, attorneys, and to enrolled agents and enrolled actuaries. And looking at Section 10.12, if we know of a taxpayer's noncompliance, omission, or error, we're obligated to identify it and discuss the consequences of that error. The rest of these practice standards deal with due diligence about when we're giving tax advice to make sure that we are appropriately looking at the tax authorities that apply, as well as making sure we understand our facts. And I'll circle back to that in a moment when we talk about compliance with the determination of who is a reportable U.S. person for FFI purposes. Next slide, please. The next several slides deal with some topical issues. In some of the tax periodicals, there's been discussion about whether trusts would be treated as financial institutions under the code. If we look at sections 1471D5 of the code, it talks about what is a financial institution, and there are commentators who are concerned that foreign trusts may be construed as FFIs that would be subject to the reporting regimens that Willis and Joseph covered a little bit earlier today. Let me go to the next slide, please. And I'm going to cover the next few slides a little bit quickly. Again, we have the reference here to investment entities, possibly for trusts. Why don't we go to the next slide, 58. Okay. The next series of slides, I give you some detail about an enforcement mechanism. The Internal Revenue Service has at its disposal, this lists a Title 31 subpoena, but the IRS could also issue a Title 31 summons. A subpoena is typically issued as a part of a grand jury process, or of course we know in a court, an adjudication of a controversy in court. But a revenue agent conducting an examination and determining a taxpayer's compliance with the Bank Secrecy Act, i.e. FBARs, could issue a summons to the taxpayer seeking the taxpayer's records about foreign assets, foreign-held assets. And why don't we go through the next slides just in some, about every 5 or 10 seconds, just flip the slide if you could. These series of slides give you a citation to United States versus, or I should say Shapiro versus United States, whereby the Supreme Court held that taxpayers are required to produce and retain records if it relates to a regulated activity administered by the government. Why don't we go to the next slide, please? And then the next slide beyond this. The Grasso case, the Marchetti case, and then the cases that follow, go next slide please, are talking about the controversy if a taxpayer produces a record in response to a Title 31 summons. Might that record production be considered testimonial and violate the Fifth Amendment? These cases, go ahead to next case please, these cases basically tell us that the courts have uniformly held that the production of information in response to a Title 31 subpoena is not considered to be testimonial or to violate the Fifth Amendment. So this is an enforcement mechanism we'll be seeing the government use more. Next slide, please. This slide just gives you an update and a reference to the Department of Justice website at the bottom regarding enforcement actions with banks and foreign jurisdictions. Next slide. Willis has already mentioned about that 2014 and 15 under the IRS Notice 2014-33 will be considered a transitory period. and there's expected light enforcement. Next slide. If you are an FFI looking at have you fulfilled your duties under FATCA, you need to make a reasonable effort to document the FATCA status of the payee and determine whether that account must be reported. And let me go on to the next slide, which is my last slide. We've heard about and followed the news reports about Credit Suisse and the $2.6 billion penalty that it paid. Another $715 million was paid to the state of New York by Credit Suisse. And we have here in the middle part of the page references to a website where you can go and check and get updates on when the government has entered into IGAs or to report the status of IGA-type agreements. With that, I thank you for your attentions and again pass on the message that it's still possible to do a voluntary disclosure, avoid a criminal prosecution, and become compliant with previously delinquent tax obligations. Thank you, Paul.
And thank you, David. David Lewis, stay with us for the Q&A section. We're going to go on to our next segment momentarily, but first I would like to issue secret word number 5, which is investment. I-N-V-E-S-T-M-E-N-T. Investment is the 5th secret word today. Please jot down investment as secret word number 5 so you'll have it for your surveys so you can get your continuing education credit. Investment, secret word number 5. Okay, now we're going to turn the conference over to Mr. Lawrence Kittle, and we will begin with him now. Mr. Kittle.
So I'm Lawrence Kittle, Commercial Director, Thomson Reuters, responsible for FATCA, and that includes the delivery of our products roadmaps and overseeing the go-to-market, as you just heard. And our main focus recently has been both customer onboarding for FATCA purposes and the documentation self-certification side, and moving further on to look at reporting and how that's evolving perhaps over the next couple of years. So that will inform some of what I go through the presentation today. And the thing that I'm going to talk about here, FATCA, the end of the beginning, it's acknowledging now we're very close to the onboarding deadlines, but that's not the end of the story. There's an awful lot still to do after that. So just look at the agenda, just click down to the next slide. 3 very broad areas. So FATCA, where are we now, where have we been, and what comes next? I think that's changed a lot over the 2 years I've been involved in this. Then looking at operational issues, and particularly around the customer onboarding and identification part, classification and documentation. How do you actually get arrive at the correct classification? And I'm really going to look at that from an operational sense. So what our customers are telling us, where we think the market's going, and how we help people address some of those challenges. And then perhaps a bit of crystal ball gazing. So beyond FATCA, I've termed this the known unknowns. So we've got similar FATCA-like regimes in various jurisdictions, the UK included, but certainly not limited to that. And then on the horizon, we've got the OECD with their automatic exchange of information and common reporting standards program, so for 2016 and beyond. And just to keep this interesting, I'm going to throw in a couple of pictures and diagrams as we go through. Another FATCA program without something out of context there. And I would say FATCA has awakened in me a previously latent interest for quoting major historical figures out of context. So I'm going to throw a couple of those in as well. Okay, so just clicking down to the next slide. So 2012, what was FATCA? Now, I became involved in this middle of 2012. So my previous background is as a tax advisor. I've worked on indirect taxes and various other duties and industry-specific taxes through the UK and through Europe since 2000, with Big Four firms for the last 5 years at Thomson Reuters. When I took on FATCA, I won't say it was simple, I won't say it was straightforward, but it was quite clear, I think, what the direction of travel for this was. It was merely around looking for the American customers of financial institutions holding overseas accounts. So within that sentence, there's a huge amount of nuance, obviously, but I think the direction was fairly clear. And we had Commissioner Schulman, as you see on the picture here, acknowledging that it was going to be of significance. Of course, Schulman is not around anymore, he's since retired, and I think maybe even he would be surprised at the direction that the process he's put in motion has taken since the initial regulations came through. Let's get to the next slide. FATCA, where is it now? So, at a time on this perhaps, FATCA's evolved, and I think what we've seen is the internationalization of what was a US outbound program. So we had, first of all, intergovernmental agreements being published, and that really took FATCA from complying with the IRS to complying with the tax law in many different jurisdictions. In the terms of FATCA becomes an international regulation, but it's also reported to local tax authorities. And that means that you get local nuances, perhaps, that you wouldn't get through the IRS. And one example of that was the Mexican IGA, originally taking the view that you would take an average balance of accounts rather than an end-of-year balance. So you begin to see localization creeping in. When you get that, you get complexity. So that was a creeping complexity coming into something that was already complex. Moving beyond that, though, you then have the interesting situation of the UK government looking at what the US is doing, realizing information is being shared from the UK overseas territories and foreign dependencies with the US, with the US Treasury, and not with HMRC in the UK. So HMRC and the British government then began to take the internationalisation of FATCA further to give a UK variant of it. And we've actually seen similar in the Netherlands with some of their territories that exist in the Caribbean as well. France has done something similar on trusts, for example, too. So what was beginning as a purely US initiative is gaining much wider currency. And the implication of that is that it's not just single regime, albeit with the different international flavours of the IGAs. It becomes a far more difficult multilateral regime to work through in that case. And then overlaying all of that, we've got the various initiatives that coalesce at the OECD around the automatic exchange of information. And I think what we're seeing there is something that was, so taking FATCA as originally around information sharing around US persons on a much, much wider basis. So we currently have, I think, 47 countries signed up. They're probably going to increase over the next little while to commit to transparency and sharing information, banking information between themselves. Not a huge amount of clarity on exactly what that means, perhaps. But I think what we do know, so with the increasing number of IGAs for US FATCA, with UK plus other European variants of that, and the OECD kicking up dust clouds on the near horizon, life's getting a whole lot more complicated. Different reporting timelines phase into this, different compliance timelines, and that's something I'm going to draw through as we actually look at the rest of this presentation. So one of the main themes I've got here, okay, so FATCA is 1 July, that's where we stood at the moment, but we need to be cognizant of what's happening in the future, where this is taking it. And perhaps that's getting slightly neglected. And to give a personal view on this, actually, I've spent a lot of the last month or so working through Jersey, through Gibraltar, through some of the UK offshore territory current dependencies. Strong awareness of what's happening in the US, perhaps less so on how the UK factors the impact on compliance processes and some of the changes that have happened. One common theme, of course, is the two slides that I've shown so far, the two quotes. So we have Sean talking about substantial undertakings. We have on this one here the OECD, the Association of Global Custodians being perhaps more explicit. A very substantial investment of money and resource in the financial industry, but also from government. There is a huge amount of political will towards information sharing. Now, we've seen discussion in media and other forums recently about data factor delays. We had IRS notice 2014-33. When is the delay not a delay, perhaps, but clearly not, because we're still going ahead, albeit with a slightly revised compliance timeline. And we've got very clearly the will to make this happen. But that does impact on how businesses comply and how they organise their programs. Just to look at the next slide then. So to take my first book, to take it slightly out of context, which has massively out of context here, less than 6 weeks away from onboarding deadline, 5 weeks perhaps. Picture I've used here, the general theme of the presentation. FATCA onboarding starts on 1 July. That is not the end of the process. And, yeah, I've had colleagues speaking to me saying, so you're winding down FATCA now. Everyone's bought what they need to do, they've got solutions in place. Well, no, that's actually not the case. We've got onboarding now. We've got the existing book of business, which demands focus and perhaps isn't getting it efficiently at the moment. But on the horizon, we've got reporting. I'm not going to go massively in this presentation, but I think that's something that we'll collectively see a lot more focus on over the next couple of quarters. Gathering information is one thing, but having process that and how we actually submit it is going to be a problematic process. So a lot of focus here is on both customer onboarding and it's on data. And despite the quote here, I think Churchill talked about the end of the beginning. It's not it's not the end. It's not the beginning of the end. This is the end of the beginning. I had used Churchill for a reason, and I'll come back to the conclusion. So just keep that in mind for a moment. Okay, so we look at the next slide. And one of the things I'm going to throw through this presentation, this discussion, is a bit of industry benchmarking. And to give a bit of background to this, at Thomson Reuters, late January of this year, we ran one of a series of webinars focusing on FATCA. And one of the things we did through that was ask a number of polling questions. So we had around 800 attendees, various industries, through various geographies signed up for this. And one of the questions we asked them was, what's the key obstacle? Now, bearing in mind this was back in January, unsurprisingly perhaps, a lack of clarity in the IRS regulations and explicitly including the final W8 and destruction. And then, to varying degrees, other aspects coming through this as well. So we had concern over future-proofing, we had lack of budget always through, and we have uncertainty over local IGA states. Some things have changed. I think there has been some clarity over local IGAs. We are in publishing the list of countries treated as an IGA. Now, you may question about the legal status of that holds, but I think the direction of travel on that is fairly clear. Some of these remain, though. I'll say that we ran this in January. We will be running another webinar with some of the following questions shortly, and it'll be interesting to compare the benchmarks we get through that as well. Crucially, we don't yet have instructions for some of the W series forms, and that does give issues in compliance. And I think the concern for future-proofing is something we'll also bring through here. Now, when we did a geographical split on this, then the concern for future-proofing is predominantly in areas that are affected both by US and UK FATCA. That's going to change with the OECD publications and how that program rolls out. I think that's something we're going to see a lot more concern rising very soon. Let's look at some of these operational issues, and I'm going to look particularly around the tax forms part of it for the next few minutes perhaps, and how that then begins to impact on other areas. Brief word on this as well, though, that we're looking at, I mentioned the US FATCA, UK FATCA, UK vary quite a lot. They both go live on July the 3rd. They are very similar, not quite the same. And the lack of withholding perhaps is the obvious area. There are more subtle differences. I'll actually come back to that and talk about future proofing. But the key thing to hold in mind here is that different variants, slightly different rules, which does require different treatments in some situations. Let's look at the operational side of this though. First, we're going to look at entity classifications and how it works through this. So, final screen at the moment, next slide please, deals with entity classifications, headed Chapter 4 and CD, overseas decision trees, CD, overseas crown dependencies, overseas territories. So, specifically looking at how UK FATCA works. And without underlining the relevance of this as well, it isn't just looking at how UK FATCA operates. The principles here are going to be applied almost exactly, you believe, to the OECD common reporting standards. So if you're not caught by the UK variant, say you're not compliant, not registered in the UK, Channel Islands, Gibraltar, Isle of Man, and some of the Caribbean offshore territories, this is relevant to looking at it from the OECD perspective, which will come down the line in a year or so. I'm not expecting this slide to be legible on screen. There's a lot of detail on there, and that frankly is not the point of it. The point really is that there's a lot of classifications under US FATCA. There's a lot of entity classifications, specifically on entities under UK FATCA. You don't always arrive at the same answer when you're onboarding an entity. And that creates a number of issues, I think. Partly is around how you actually onboard the entity. So are your systems sufficient to keep track of more than one entity basis? Can you track something that is both reportable in one jurisdiction and non-reportable in another? I'll go through a couple of very more concrete examples. So looking to the next slide here, and this is looking very specifically at entity classifications between the US and the UK. I've picked out 4 here. There are various consultations and discussions going on, so things are correct as of time of doing this broadcast. But these things may change. Industry pressure may be brought to bear on the different governments. But I think, again, looking at the direction of travel, we assume we're in a fairly stable position on this. And what we have is a number of classifications that exist under US FATCA and do not exist under the regime of the UK crown dependencies overseas territory. So, for example, a non-participating FFI, which doesn't exist in UK FATCA. So the assumption is it's treated as a reporting financial institution for UK FATCA purposes. That is an assumption. This should not be taken anyway as tax advice, obviously. But that is my understanding of how that goes through. Exactly the same thing for owner-documented FFIs. So for those where perhaps those are small when the parent entity is allowed to put through the documentation for them. Again, no concept but under UK FATCA. Similarly, registered deemed compliance. That's the same scenario, doesn't exist under UK FATCA. And I think this reflects a difference perhaps in the attitude of the UK government and Treasury and the US as to where they see the potential for tax evasion, tax avoidance, which after all could be absolute key in the bottom line to this. This is the gap between 2 countries, different tax regimes, but perhaps similar outlooks on the world. I think my personal view here, again, emphasizing personal view, is that we can expect to see more variance as FATCA widens, or perhaps more properly, as FATCA-like collection and reporting widens to cover the 47 plus countries that have signed up to the OECD so far. It's great to expect consistency. I look back to see the role that I held when I was running various teams providing indirect tax solutions, particularly on VAT and service tax. As you look at how VAT works in the European Union, all comes from the same two EU directives. You have the situation where the Irish VAT return has 5 boxes on it. You have a Hungarian return with something north of 80 boxes on it from the same regulations, remember. So we see variance, a huge amount of variance within the European Union and how the broadly similar tax is treated. Now, perhaps tax is closer to some of the statistical reports we get through the EU, such as interest tax and sales lists. Again, you see a lot of regional difference in that as well. So I think it's naive to expect that common reporting standards will be exactly that, at least totally common. So I don't think they will be. I think we're going to see loads of variance. And I think catching the gaps between the parts of it is going to be complex. And that does warrant looking, I think, quite carefully at the tax entities, particularly entities that you're on board, to work through what those decision trees look like and what they should be, and to make sure that the exceptions are captured. Possibly even through an automated process and through manual instructions and relying on frontline staff to do that, because with the best will in the world, most bank frontline staff, they're not tax trained. They're there to service the customers rather than the regulators, after all, as the main purpose of the business is. So I think picking up those nuances is probably a systems solution rather than an individual one. Slight digression there, but just coming back to the slide on screen at the moment, so the entity classifications and the final category there. I think this is quite interesting. I think this both from a political standpoint, but also from a compliance one. So the US classification is non-reporting IGA, FFI, non-profit organisation. Now, charities can fit either of those. That's more commonly the second. Now, UK, by the US, under US tax, the charities are exempted. So there's no particular concern. There's no reporting. Not the case under the UK FATCA. HMRC have publicised, I think, through the mainstream media, that they believe that there's a certain amount of tax evasion taking place through charity structures, particularly offshore charities, particularly charities offshore in the UK, can depend on overseas territory. Particular focus on that from HMRC. With that increase, the political will driving a difference in classification. Most non-financial charities in the UK classified as an active NSFE, so those that aren't carrying investment activity. Those that are probably just reporting FIs, become a bucket for most others, but in lots of reporting in other areas. And I'm going to move to the next slide now. This is a little diagram just showing how we believe these classifications differ. So the specific scenario I'm looking at here is for the Guernsey controller of a Jersey charity. Not a particularly uncommon scenario. They provide a self-certification to their bank, which is the UK financial. And that UK FI has an obligation to report their overseas customers to Revenue and Customs, both on the basis of US and UK FATCA. But the classifications are interesting. So charities exempted under US FATCA, active NFP, non-reportable, end of game basically. You do not pass go, you don't have to do anything. But for UK, it's different. Two reporting lines here. The charity itself fits under the definition of a Jersey specified person, as a passive NFP. And it's also, given the fact that it's controlled out of Guernsey, there's a Guernsey controlling person there. So how do we cope with this? We've got two different classifications. We've got to go back to the controlling party as well. And we're looking at different levels of reporting based on different countries. So we've got different data with different reporting. Unless systems are configured to do this explicitly, I think that becomes a challenge. So part of it is a systems play. And part of what we've been doing at Thomson Reuters is working through how those classifications work, how you can hold those two different categorizations. So the crucial point there, I think, second one, again, dives in slightly more detail now, is that self-certification itself. Conventionally, very often at the moment, that the US form, form W8, doesn't quite do the job we need it to here, in that it doesn't capture a UK FATCA status, very obviously, it's an IRS form, and also it doesn't really allow for holding dual statuses. So one status, that's it, you can't do that. And it doesn't capture tax of evidence, which is a crucial part of what the UK and the OECD model. So to move to the next slide, and I'll get to this fairly quickly, I think. So looking at W8 forms at the moment, the major thing we've been doing with a number of our customers over the last 3-4 months or so is taking them through a process of migrating from paper tax forms, so sending out whole WCS plus instructions to their customers, migrating them onto the electronic form process, by which the customer sends a web link to your website. There's an electronic questionnaire on the website that takes the customer through the process of selecting, first of all, which WCS form they should complete by means of a number of questions, and then taking actually through that form filling process itself. So, for example, taking the rather nasty W8 Benny from 7 or 8 pages down to a manageable series of questions which are answered through drop-down systems along that FATCA status. That makes the form gathering process much more efficient. Crucially though, because it's not a paper form, you have got the ability to add extra information into that. And that happens, by the way, already. There's an IRS program, Memorandum of Understanding, which underpins a lot of the electronic form processes that we work through. Into that, the IRS has already introduced their own 1W8 question on the substantial presence test. It's comparatively easy to configure electronic W8 forms to include things like tax residence, like a UK fact status, and anything else actually relevant to gather. So that becomes a more rounded form that provides a lot more information. And again, they can go through the electronic process, signed electronically, validated electronically. We believe it's giving a lot of our customers a great deal of benefit at the moment. There is the alternative to tax forms, and that's what the IRS define as similar agreed forms. So moving to the next slide, forms and self-certification, W8 or something else. And just acknowledge copyright on this. This is from one of our advisors, Deloitte. And what they're analysing here is basically the gaps you have between whether you rely on W series form, which is rigid, but is very well recognised. The other extreme, where you can rely wholly on self-certification or actually public information for some classifications and look at the level of risk that exposes to. And our view at the moment is that it's kind of a hybrid of the two. If you're reporting under Chapter 3, the W8 required, you can do with the tax treaty information on there. Otherwise, however, self-certification can work. I think the agreed part of similar agreed forms is perhaps a misnomer at the moment because it does beg the question, what is it they agreed with? And we think we work with those industry associations and bodies, with customers directly and with tax authorities. That agreed point is a moot point. They are similar forms, exactly, they're not agreed until they can actually come through an audit process. Be that as it may, I think putting them through an electronic process and giving somebody the standardization of policy. And one of the things that we're building into our electronic W8 platform is the ability to select, basically self-select a tax form at administrator level that can then be issued to a bank's customers. So we include a superset of questions because everything can ask around self-certification, individuals and entities. And you can then choose to include or exclude specific questions based on sign-offs and header and footer information based on specific requirements. So we believe that's something that is answering the questions largely around self-certification, making it more flexible to cope with the different regimes. Probably enough on the operational point of self-certification and what some of our customers are working through in the market. So we'll move ahead now to the next slide, and my second sort of figure out of context is Donald Rumsfeld. And this refers back to a rather famous speech that he made some years ago, specifically about weapons of mass destruction. Arguable whether FATCA fits into that category, but I think some people have some fairly strong opinions, both sides of the argument, I think. But Donald spoke about the fact there are known knowns, there's known unknowns, and there's unknown unknowns. And I quite like that in the FATCA context, particularly looking into the bit of crystal gazing here. Some things we know FATCA is happening, we know it's going on 1 July. We know the IRS published a huge amount of guidance for this doing this to come. So that fits into a known unknown. How do we validate a W8 then E? We don't quite know that. For some, it is simply unknown at the moment. So I'm just going to pick out a couple of themes here. For the benchmarking again, we asked the same survey back in January. How straightforward is it to amend the FATCA process to cover a similar regime? So the OECD, for example. Results weren't inspiring, to be honest. Additional rework through most, 56%. Fundamental change to 24%. I have to say I was slightly worried that of the 800 or so attendees we had, 5% of them who were straightforward but hadn't yet started the FATCA program. Bear in mind it was January, a FATCA-specific webinar. I think they're probably missing the bus slightly, but perhaps very good reasons for that. But the point there, I think, is that FATCA has evolved. Perhaps programs haven't evolved quite as quickly, and there's a bit of catch-up work to do. To look through known knowns, known unknowns, perhaps. I've picked up here specifically for attendees from the UK, territories and dependencies. What do we know about the UK regime? Well, we know most. We know that there's no withholding tax. We know that in the absence of withholding stick, there probably are slightly more draconian penalties, and we believe they fit under local tax law. That means that it becomes criminal penalties, so potentially imprisonment for non-compliance, say potentially. We know where that's going to go to. Similar exemptions, I think the word is similar, not the same. Similar in the concept, although no phone numbers, helpfully, I think. And it's point of tax residence rather than place of birth, so reflect the difference between UK and US tax law. Interestingly, limits made in US dollars. That's just exchange rate problem, perhaps makes it a bit more consistent, perhaps. I think there's pluses and minuses both sides of that one. But the point there is we know most of what we're doing, which is a good job, comes in 1 July. Perhaps the message hasn't permeated the industry as much as it could have done, but a lot of information is out there. That's UK FATCA though. Moving ahead to the OECD automatic exchange of information, I classify this kind of an unknown at the moment. I think there is a great political will, as I mentioned earlier. We believe, the first bullet on the slide here headed automatic exchange of information, OECD automatic exchange of information. We believe that it will be a bilateral regime governed by a series of bilateral sex treaties. Now, I ran the maths on this a little while ago when I think 42 countries signed up. 42 countries means, I think, 960 odd different bilateral treaties. That's tough to comply, but a lot to keep track of, and that's just going to grow. We believe it's reporting to local tax authorities. We believe that there will be things around data protection, which obviously have been presented with FATCA as well. We believe it's fully reciprocal. We believe the US will sign up for that, but we haven't quite got there yet. I think a point on that, though, is that we expect to see US FATCA and the OECD exchange information in lockstep. Withholding, I think, is a crucial part of the US side of it. Information exchange for the OECD. So I think we'll see parallel regimes. I suspect the OECD will supersede the UK FATCA. That will just simply roll into it when reporting comes to 2070. But I think US is going to remain outside. So the dual regimes, I think, are foreseeable. Again, personal opinion there. So moving off this then, so I think we're going to go to the final slide and just perhaps draw a few conclusions together here. I returned to my theme earlier on, the end of the beginning. The end won't be here anytime soon. FATCA is here, not going away. It's very clear and present in our minds. It's going to change. So existing book of business goes through. Following the existing business, we then move on to a reporting cycle. We then go to the OECD. There's still the prospect of passing payments through withholding, various things going on to 2016, 2017. So if those mind thought it was my role there, perhaps finishing in summer of this year, just beginning, I think. A couple of other things perhaps. Categorization, self-certification, as I mentioned earlier, is complex. It's, there's different classifications of different regimes. You can be the opposite situation where as a custodian, you can have a GIN which exempts you from US reporting, but doesn't exempt you from the UK because that's not considered exempt of our scope. So even though a GIN number is not sufficient to deem something not reportable, I think that's quite interesting to say there. I think we realise the OECD regime is going to happen because parallel regimes, as I said, I think that presents a lot of compliance challenges. And just to sum up, and perhaps to return to my original point on Winston Churchill there, I said I'd come back to him. Now, he was voted greatest living Briton in the BBC polls 2 years back. He's a very British person, one would think. But he's got an American mother, essentially US Indonesia. He was born in he lived substantial periods of his childhood in Ireland, probably, but as a reportable person in Ireland under the OECD models, from what we understand. And through military service, spent substantial time both in Sudan, in Egypt, in India, and other places. In each period of residence there, probably reported to each of them. So I think you see there just one person, albeit that's very exceptional, not quite as straightforward to see exactly where that is reported and how you need multiple levels of reporting. That becomes more complex, I think, as that widens. I don't mean to enter a downbeat note with that, though. I think there's a lot of good things that can be done to mitigate this. There's a lot of good systems in place. A lot of our customers are well on the way to complying both with UK, US, and future-proof with the OECD. I think a technology framework is important. I think looking at the self-certification is important in classification, but very clearly on the way, and I think we're in that way. So thanks for your attention, and speak to you soon.
We're going to move along to our questions and answer session. We'll send a digitally enhanced recording of Mr. Kittle's comments with a transcript of that last segment for your review. So what I'd like to do now is talk to the remaining 3 members of the panel and invite you all to take part in our Q&A segment. Now, panel, the way this works is if the question is being asked on a generalized basis, any one of you can feel free to jump in first, and of course all of you are welcome to respond. And if we have any questions that come in directed to someone in particular, of course that person would ask first, and the rest of the panel is invited to share their points of view. So with that in mind, let's go with question number 1. If a foreign financial institution does not have U.S. account holders, does FATCA still apply? If a foreign financial institution does not have U.S. account holders, does FATCA still apply? Who would like to go with that?
Well, I guess I would say we may want to ask what you mean by U.S. account holders, because it may be that if they really have no U.S. account holders as defined, then they don't have, obligations to report on them. But just to keep in mind that a U.S. account holder also includes a non-U.S. account holder if it's owned, beneficially by U.S. persons, at least in excess of a certain threshold. So that would be one caveat.
Right. And I think I would point out that, FATCA applies to, the purpose of FATCA is to identify U.S. account holders. And it sets up this very detailed process in a set of definitions and a set of requirements to search for them. And unless your entity is doing that searching, then you can't really say you've abided by it. And the problem would be if you became non-compliant or simply didn't do any even report to that, you could become subject to withholding. So it's kind of the search for U.S. account holders that's important. Even if you turn out you don't have any, FATCA still applies to you, but just what you have to do is very limited.
Okay, panel. Well, let's go ahead. Other points there?
You certainly have to do a minimal due diligence so as to know whether you do have any U.S. account holders, again, as defined. So, yeah.
All right. Let's take another question. Does a non-U.S. taxpayer who earns U.S. salaries but is not a U.S. citizen or U.S. tax resident need to file Form 9022 FBAR to show his bank account activities outside the U.S.? I'll repeat that. Does a non-U.S. taxpayer who earns U.S. salaries but is not a U.S. citizen or U.S. tax resident need to file Form 9022 FBAR to show his bank account activities outside the U.S.? Thoughts on that?
Yeah, this is Dave. Basically, you're talking about a non-U.S. taxpayer that has accounts outside the U.S., and in that instance, there would not be an FBAR reporting.
All right. Are there any other thoughts on that particular point, or should we move on? Okay. What we're going to do here is we're going to give out secret word number 6, so we can wrap up the secret word segment, and it is exceptions. EXCEPTIONS. Exceptions is the 6th and final of today's secret words, and we're going to ask you to please fill that in on your survey when you receive it as the 6th and final secret word, exceptions. And thanks, everyone, for your attention to that. And now here's a question that's designed and targeted for David Lewis. So, David, if you would consider this and answer, and of course the other members of the panel can also give their points of view after David is complete. A taxpayer can qualify for streamlined procedure, but has the ability to timely file 2013 income taxes and FBAR. However, streamline requires no filing after 2009. Should the CPA advise him not to file timely for 2013 and include years 2011 to 2013 in the program, or will the IRS look favorably on his attempt to become currently compliant and still allow to streamline? What do you think, David?
Okay. Paul, if you go back over I just want to make sure I've got the facts right and the question. If you could just
I'll review it. Sure. A taxpayer can qualify for streamlined procedure, but has the ability to timely file 2013 income taxes and FBAR. He lives abroad, has a 6/15 due date and potential 10/15 or even 12/15 due date. However, streamline requires no filing after 2009. Should the CPA advise him not to file timely for 2013 and include years 2011, 2013 in the program? Or will the IRS look favorably on his attempt to become currently compliant and still allow streamline?
Okay. All right. Understand now the question. The 2013 return should be filed timely. And likewise for the 1040, and likewise for the FBAR that's due for the period ended 12/31/2013. With respect to the periods prior, you can avail, if you qualify with the $1,500 or less of income tax due in each of those years, you could qualify by picking up the 2009 return and moving forward. And then, of course, the FBARs for the prior periods, which would be, in this instance, if 2013 FBAR is filed timely, then it's the 6 years going backward, starting with 012, 11, 10, et cetera. So I would recommend that as our obligation is to make sure we're recommending to people to comply with the deadlines and to go forward and file. And in that case, I would say be compliant with 13 and just pick up the other periods that have not yet been filed.
Okay, thank you for that. Any other panel members have any thoughts on that particular point? All right, we'll go on to another question then. What ability does the IRS have to actually go and place a lien on foreign assets if a person decides not to comply and never return to the U.S.?
This is David. I don't believe a lien. A lien is, of course, is authorized by Title 26, and it encumbers U.S.-based assets within the United States. I do not believe that that a lien, it's a nullity. I do not believe that a lien could possibly be filed in jurisdiction outside the United States. Instead, perhaps the government would have to reduce the assessment to a judgment and then attempt, not through a lien, but possibly through trying to, quote, domesticate the judgment in a foreign jurisdiction, attempt to collect against assets there. But a lien itself would not be effective. And I'm not sure to what extent a judgment obtained from a U.S. court regarding an unpaid tax assessment, I'm not sure how that would be applied. It probably would be the function of an intergovernmental agreement between the Treasury and the foreign nation. There may be something in a treaty that would cover collectability of judgments. So I would check that, but it won't be a lien itself. You'd have to look further into treaties and what a treaty might provide.
Let's try this other question then. If an FFI has no investments or U.S. source income, why should it be concerned with FATCA? And if FATCA applies, how do the withholding rules apply, and who pays the tax withholdings?
Well, if they're never going to have any U.S. source, I mean, the sword is the withholding on U.S. source investments. Remains to be seen how they define, pass-through payments, as we had discussed, which would be potentially non-U.S. source payments, but that are somehow deemed attributable to U.S. source payments. So that would certainly be something that could still impact you, even if you thought, oh, I don't have any U.S. source investments.
Any other thoughts on that? Okay. We have time for one more. And one of our attendees says that they have some clients in Israel who've told them that they will move their money to banks not going under FATCA since they do no business in the U.S. Is that correct? Will it work? Not that the person writes in, not that they're encouraging them to do so. So what about that? Clients in Israel told this person they will move their money to banks not going under FATCA since they do no business in the U.S. Is that correct, and would it work?
Well, I'll take a stab at that. I'm sure Willis and Joe may have some thoughts as well. But this question is suggesting that compliance with our income tax laws is optional, or is somehow subject to discovery, or some other kind of means by which the government will learn about this. I would certainly, under Treasury Circular 230, if the questioner is a U.S. attorney, a CPA, an enrolled agent, enrolled actuary, we cannot advise persons about how to construct their affairs in such a way to avoid detection. That could well be viewed as not only a violation of Treasury Circular 230, but potentially further an act of conspiring with another to underreport taxable income or to avoid or evade the reporting of an account. So I don't think that's an option at all.
Any other thoughts, panel?
Yes, I would completely agree with that. And I think there are actually parts of FATCA that are specific to this type of advice that it's one of the things that actually could trigger a FATCA problem is any type of structuring or planning to try to evade the purposes or results of FATCA.
Right. Yeah, I would definitely agree as well.
Well, panel, thank you very much for all the very fine work you've done today. We would like to thank our speakers and attendees for carving time out of busy schedules to make this event a very successful one. Now check your email because you have a message coming from the Knowledge Congress asking you for your feedback on today's event. It's a survey designed to be completed in less than 2 minutes, and it helps us make the best use of your time at future events. We appreciate and welcome your comments. And as a reminder, if you're applying for continuing education credits, the survey is mandatory as your state bars and boards require that we maintain a completed survey from each attendee. Now, if you request a recording of the event and or a certificate of attendance, you will receive the relevant information via email within the next 24 to 48 hours. Attendees, just a final reminder here, sign up for one of the unlimited programs today. There's a free program and a paid program, which is just $299 all in for 6 months. Registration forms attached to the survey email. Sign up today and take advantage of all the discounts and extras. And also, please be sure to check out our outsourcing services, which are also attached to the email, to see how we can help your firm save. And please follow us on Twitter. That's @KnowGroup to receive updates for this event as well as other news and pertinent information. Well, ladies and gentlemen, this concludes our event for FATCA guidance for foreign banks. Are you prepared? A live webcast. Any questions for one of our speakers? Send them directly through your contact material and your events materials. If you can't find that, either make a request for that information or send the question to us and we'll pass it along. And you can send those requests to info@knowledgecongress.org. We're going to ask you at this time to please disconnect your phone lines. Many thanks to all, and we hope to see you at future events. Bye now.